All right, now talking about child support. The important thing to know right off the get-go about child support obligations, and a lot of clients have misconceptions about this, but the obligation to pay child support is completely separate from parenting time. Even if the person who's paying child support never sees the child and has no role in the child's life, that obligation to pay child support still exists, okay? So frequently we have people who come in and say, well, why should I pay child support? I have nothing to do with them anymore. And it's like, no, it's completely unrelated. You have to give some information and sort of help to guide the person into understanding that their child support obligation is not tied to time that they spend with the child or to a relationship with the child. Child support can be payable by non-guardians and step-parents sometimes. It's important to recognize that even though it's paid to the other spouse, it's for the benefit of the child, and it's different from spousal support in that way. So the purpose of it is not to subsidize the other spouse's living, but really to cover the expenses that person is incurring for the child. So in BC, the age of majority is 19. So every child who's under the age of 19, a child of separated or divorced parents, is eligible for child support automatically, okay? And I'll go over different exceptions that apply to children who are above 19 in a minute. But it's an automatic obligation, it's an automatic eligibility. So in Canada, we have the federal child support guidelines. These were created to try to reduce arguments about the amount of child support. So they've been adopted in every province, including BC. And what they are is a set of tables that sets out what amount of child support is payable based on someone's income, how many children they have, and what province the children reside in. So it's a very simple exercise, and I've included a link here. I don't know if it'll work if you get your materials, but if you go to Google and type in child support table lookup, there's a very simple calculator that all you do is put those 3 pieces of information in, and it tells you what the guideline amount of child support is for your income. So it's very easy and simple for people to find out what the child support amount is that they're supposed to be paying. Okay, in terms of child support amount, so normally when you see it payable is when one person has the children most of the time, and then it's a very simple, I have the children. A shared parenting arrangement is anything from above 40% of the time. So if you have the children more than 40% of the time, and the other party has the children at least 40% of the time, you're in a shared parenting arrangement. So sometimes what happens, although it's not always the case, is that parties will calculate each of their child support amounts, and then one party who has the higher income will pay an offset amount to the other party. Sometimes parties, if they have really similar incomes, will just say, we're not going to pay child support to each other because it would essentially just be, $500. It doesn't really make sense. Or it's just, it's like $10 difference between the 2 payments. But if one person has the majority of the parenting time and they're not in a shared parenting arrangement, then they will receive child support only from the other spouse. They won't have an obligation to pay child support if they have the children the majority of the time. Okay? Okay, so types of child support. So there is the regular child support monthly payment, which is based on the 3 things that I mentioned. So that is the regular child support amount that's paid every month. It is non-taxable to the recipient spouse. And the other category of child support is special expenses. So these are categories of expenses that are above and beyond what child support or the person's income would cover. And I'll go through what some of the categories are. So in looking at these, they have to be necessary and reasonable for the party's means. So Lower income parties, there may be less things that the court views as reasonable because there's just not enough income to go around. So for example, if you and your ex-spouse have a combined income of $60,000 a year and your child is enrolled in horsebacking 4 days a week, which costs $10,000 a year, the court is not going to view that probably as a reasonable expense that would fall into this category because the parties simply can't afford it. Of course, each parent is able to pay for whatever they want for their own child. If one of those parents in that relationship wants to enroll their child in horseback riding without asking for contribution from the other parent, that's fine. But if you want the other parent to contribute, it has to be necessary and reasonable. So unlike the best interests I talked about, which is an open set of categories, and the court just gives us a list of factors to think about, special expenses is a fixed set of categories. So if you have an expense that you're trying to claim as a special expense that the other spouse contributes to, it has to fall into one of these categories. So it either has to be childcare, medical and dental insurance premiums, out-of-pocket health care over $100. So a frequent one we see for that is, when kids get old enough to have braces, that will fall under that category. Educational expenses, including post-secondary education, and I'll talk about adult children and child support in a minute, and extracurricular activities. In terms of daycare, that will almost always be considered necessary and reasonable, provided that daycare is incurred because one spouse is going to work, or they're doing education or training, or suffering from an illness or disability that prevents them from being able to care for the children themselves. I should also mention that sometimes the needs of the child will outweigh the cost of the expense to the child. And something can qualify as a special expense even if it causes hardship to the parents. So an example of that would be counseling services, which you see a lot of parents enrolling their children in because they're often struggling with dealing with the fact that their parents are in conflict after they're separating. So the court may see that as reasonable and necessary, even though ordinarily the parties may not be able to afford it. Or tutoring services where the child needs some extra help to get through school. Or lessons and coaching in arts and sports where the child has a special talent that should be nurtured. So often it's a misconception that anything I enroll my children in is automatically a special expense if I can afford it, but that's not always the case. The child has to have a special talent in that area. Usually parties are on the same page, especially if their kids are telling them, I really want to go to soccer, and they won't be too hesitant to contribute towards that. But sometimes it can be a point of attention. One parent is really gung-ho about hockey and the other parent doesn't really care and doesn't want to contribute. And you might get into arguments about whether the child has a special ability such that it's appropriate to meet their needs to pay for that expense. So it can get a bit messy. Okay, so I mentioned that I would talk about this. So now we're talking about child support for adult children. So once a child is 19, they are above the age of majority, above or at the age of majority, and child support is no longer automatic for that child, okay? So if a parent still wants to seek child support after their kid has turned 19, the onus is on them, basically the burden is on them to say why that should be the case, okay? So in order for child support to be payable for an adult child, they have to be, for one reason or another, unable to withdraw from their parents' charge. Common reasons that we see for that, one we just had recently, we had a 24-year-old adult child who was disabled. In that situation, if the child is unable to work or unable to support themselves or live on their own, then you could see child support being payable for longer than just 19, and potentially for the rest of the child's life if they're really struggling. Or if the child is attending university or college. So in those situations, generally, the court will allow an adult child to benefit from child support for one program of post-secondary study, which means one degree or diploma, so long as the child is enrolled full-time. So if a child is going for their undergrad and then their master's and then their doctorate and their postdoc, the court isn't going to impose a child support obligation for all of those degrees, just generally the first one. And I mentioned before that the child support amount is very easy to calculate online for a child who are under 19, but if children are older than 19, it's not necessarily that really clear table amount. It can be a different amount depending on the child's needs, means, circumstances. So for example, if the child is getting a lot of financial aid for their post-secondary education, or if they're working part-time and they're contributing to their own expenses, then that might be an argument to say that child support should actually be less than the guideline amount because the child is able, at least a little bit, to contribute to their own expenses.